Okay, we should have just heard a little alert that says that this session is being recorded. So my name is Kim Morgan. I'm the Outreach and Communications Coordinator at UCL Biochemical Engineering, and it's great to have you with us today. I hope you're having a good week so far. It's only Monday, but the sun is shining here in southeast London, and yes, it's looking very busy already. So first of all, can I just ask, just what I'm going to do is I'm just going to set a couple of things up. And if I can ask, if you can hear me, if you just logged in, if you just hear me, just type yes in the webinar chat. You should have a little button at the bottom which allows you to do that. Great, thank you very much. That does two things. First of all, it lets us know that you can hear me. Second thing, it means that the chat is functioning. So it's a really handy thing that you did that. Thank you very much. So I can see that I think we've got most people joining now who are going to be able to be with us. So what I'm going to do is I'm going to hand over to my colleague, Dr. Bernice Wright, in a moment. But before we do that, this session is being recorded. A link will be shared afterwards. If you have any technical problems at all during the session, please let me and the other panelists know using the chat function. If you have any issues with sound or video, anything like that, please let us know. We'll see that straight away. We're looking forward to your questions. If there's anything you'd like to ask, please can you put it in the Q&A function. It's a lot easier for us to deal with your questions in that format. We can go through them, and sometimes we might send you a link. You can also ask them anonymously if you wish to. So that's an option that's open to you. So please put your questions in the Q&A box, and any technical problems, please put them in the chat. I'm going to turn my camera off in a moment. I will be available in the background if there are any problems. Otherwise, I'm going to hand you over to my colleague, Dr. Bernice Wright, who will introduce our guests this afternoon. Over to you, Bernice.
Thank you, Kim. So hello, everyone. Thank you for being here today. I'm going to introduce Jennifer O'Farrell, who's a patent attorney, and Ben Hood, who's also her colleague. They work for the D. Young and Company attorneys firm, and they will talk about a career or developing a career as a patent attorney. Okay, so I'm going to hand over to you.
Bernice. So I'm Jenny, as Bernice just said. I'm a partner and patent attorney at D. Young & Co. I'm going to introduce myself a little bit further in a minute and then tell you a little bit about a career as a patent attorney. But I'm also joined by Ben Wood, who's one of the assistants in my team. Ben, do you just want to give a really quick introduction, and then we can talk a bit more about you when we move on to your section?
Yeah. Hi, everyone. Yeah, my name's Ben. I'm a trainee at D. Young & Co. I've been at D. Young for a few years now. So hopefully I'll have some insight into what life is like as a trainee in patent law. So I'll go into a bit more detail in my session in a bit. But yeah, back to you, Jenny.
Thanks, Ben. So I'm going to try and share these slides. Hopefully this will work. Yeah, we can see those. Sometimes when you put them into slideshow mode, it then has a bit of a problem. So can anyone see those?
Yep, it's in presenter mode at the moment.
It's in presenter mode. Right, we'll go ahead with these as they are then. It means I can't see anybody's faces, but it's all fine. Okay, so as I said, I'm Jenny, and I'm a partner and patent attorney at D. Young & Co. We are one of the largest UK patent firms. I'm going to talk to you a bit more about what we do and also a bit about my role and my background. You're then going to hear from Ben, who is a trainee in my team and probably can give you a bit more insight into getting into the patent profession and also life as a trainee. If you do have any questions, you can add those in the Q&A session as we go through, and we'll probably pick most of them up just at the end. So we are a very large firm. We have offices in Southampton, where I'm based, in London, where Ben's based, and also in Munich. We're one of the largest firms in the UK, and we have large teams on both the ElecMech and the ChemBio sides. So we have a combined ChemBio team, which includes our chemists, our biotech, and our life science people, so a whole sort of spectrum. We've also got, as I said, a large ElecMech team, and that allows us to work with them on inventions that might cross both teams. So we're doing some work with them on tech bio inventions at the moment, and also we do some work with them on sort of medical devices and also on software inventions, particularly the application of software to various biotech innovations such as drug discovery, but also things like clinical trial protocols and organizations of those. We're a top tier firm. We're top tier in all directories. We have an interesting client base, which I'll run through in a bit more detail in a minute. And we have a large body of trainees. As I said, Ben is one. We've got one who starts next week. We have one who started last week. We've got one who started in January, one who started in November, and that's just on the biotech side. So we have a large body of trainees, and as I hope Ben will tell you in a minute, that means that they can do things together, they help each other, and it's a really good place to train, both because you get good input from the partners and the senior associates, but also because you've got a large body of trainees to talk to and to ask if you have any problems.
Sorry to bother you. Your slide hasn't moved on. It's still on the first one. Is that okay?
So which one's it on at the moment, Kim?
It's got the holding one with the
yeah, so I think it
okay.
doesn't move on. I think what we need to do is come out of the presenter mode.
Sure.
Which now I don't know how to do. Just a minute.
We can see your mouse now, I think. So
is it now just on the slides?
yeah,
it's just move forward to the next one. So we can,
I think we might
see the row at the left and the main one as well. So it's kind of in your view.
Yeah, I think when you put it in presenter mode, it doesn't work. So apologies, but we're just going to run through it like this. So look at the big slide here. We'll move that and look at the big slide here and just ignore this bit on the left. Okay, so can we now see the slide that says about me? Perfect. Yeah. Right, let's carry on from there. Apologies for the slight technical glitch. Okay, so about me, I did a degree in biochemistry at the University of Oxford, a master's degree, and then I started at a large UK patent firm in 2006. I did the certificate in intellectual property law in 2007 at Queen Mary, and I qualified as a patent attorney in 2010. Ben, I think we'll talk to you a bit more about the exams in a minute, but that's how I qualified. I then moved to another large UK firm in 2012, and I became a partner there in 2016 before I moved to this firm in 2020. I'm intending to stay here now, and this is a really great firm to train in, which we'll talk to you about a bit more in a minute. So I'm going to run through the types of clients that I work with and that we work with as a team. So we work with a whole range of clients, from universities and small startup clients through SMEs, investors, all the way through to large pharmaceutical clients. You might think that one of those was more interesting than the other. Some people really like working with universities and small startups because the technology is really interesting, really innovative, and people are really pushing boundaries. Some people really like to work with the large pharmaceutical companies because that's where the value is, and it can be more commercially relevant. Personally, I like to have a spread of clients working across those areas. It means you've got some smaller clients who need a bit of hand-holding, a bit of looking after, and that's quite a nice thing to be able to be involved with. But I've also got some really large clients working on important innovation, which will be really commercially relevant. At the moment, I'm doing some of the patent work for Novo Nordisk and their Ozempic product. We also do some of the patent work for BioNTech. So we have a lot of big pharma clients who we enjoy working for. So the types of work that we do invention spotting. So where the inventor will come and say, I've invented this. Is there some patentable invention in there? If there is, we draft patent applications. So we work with the inventor to describe their patent application. A patent application is a big description of the invention, and it's got some claims at the end that define the legal monopoly. So we'll work with the inventor to determine what their invention is, and we include all the scientific details in that as well. We then prosecute the patent application at the European Patent Office. So there, the Patent Office may say, your invention's not new or it's not clever, and we'll have a written dialogue with the examiner where we explain why our invention is great or why we will need to limit the claims slightly to a narrower scope in order to get the client's invention protected. We also do a lot of opposition and appeal work. So when a patent's been granted at the European Patent Office, you can oppose it, or any third party can oppose it. And we defend our clients' patents, and we also attack other people's patents. As a patent attorney, that's the closest you get to sort of in-court proceedings, and it culminates after a few years of written argument in oral proceedings, usually in Munich, but sometimes by Zoom, where you sort of go and argue in front of the Board of Appeal, and they will sort of decide whether the patent is to remain or whether it is in fact revoked. We also do some FTO and due diligence and landscaping type work, particularly for our smaller clients, but also for our big pharmaceutical clients as well, where we look at what else is out there, what other third parties are involved in this area, and who may have patents that would put a stop on your activities. So a patent is a negative right, it stops you from doing something. So if somebody else owns a patent that's going to stop you from doing what you want to do, then you would need to know about that, or your client would need to know about that. And we also look quite a lot at IP strategy. So when to file a patent application, what to put in, whether to try and file everything in your first patent application, or whether to actually present just the bare bones of the invention and then have follow-on patent applications relating to more developments as those are made. So those are my roles as a patent attorney, but I'm also a partner. So I have other roles which are not directly related to the science and the patents themselves. So I do a lot of work on business development, where we try to get new clients and we try to get more work from existing clients. The best way to do business development is actually just to do a really good job, and that's what we need Ben and the rest of our team for. But we also do active business development, where we go out and visit people and give talks and see whether there are other clients who we would be able to help. I do quite a lot of client management, so looking at whether the client is happy, whether they're happy with their pricing, whether there's anything else we could be doing for them, and acting as a contact point if anything goes wrong for any of the attorneys in our team. I also look at our recruitment, so when do we need a new patent attorney? We don't necessarily recruit each and every year in biotech and life sciences, but we recruit when we need to, and then we want to get the best people. So looking at how we're advertising, are we advertising in the right places to get the right people, irrespective of their background? And are we making sure that we've got the right amount of work and the right types of work for the people we're recruiting? And also training. When people arrive as a trainee patent attorney, they've got a great grounding in science. They've usually got a PhD, and I'm sure that all of you have scientific knowledge which is more up to date and more advanced than mine. But when people start as a trainee patent attorney, they don't know anything about patents. So we spend a lot of time training them. They do external training courses, and then they sit exams, which Ben will talk to you about a bit more. But we also do a lot of training internally, where we talk to our trainees every day about the types of work they're doing and how they could improve the work product they're producing. Part of that also is involved in team management, making sure that we've got the work being given to the right people at the right level, and everything is running smoothly. And I also do some work in looking at our budget and accounts and making sure that us as a business can continue. So obviously it's important for our clients to be able to budget and to know what's going on with their business, but we are a business too. And one of the roles of a partner is to be involved in that. This is my last slide before I pass over to Ben, and it's called A Typical Day for a Partner. There isn't a typical day as a patent attorney. All the days are different. You might be sat in your office doing work yourself. You might be visiting a client. You might be having a client visit you. You might be engaged in all proceedings. You might be giving a presentation. Every day is different. And that's one of the things that's really great. And I think Ben will talk to that a bit more as well. But just to give you some kind of insight into what my day does look like, there are several different things on that slide. So on the left, I talked a bit about team management, and that's something I do actively every day. So some element of training, some element of balancing, making sure the team are okay, phoning them to make sure that everybody's got the right level of work, everybody's managing what they're supposed to be doing, and that the work is shared around appropriately. Some element of recruitment, that's not happening all the time, but it is in our minds quite a lot of the time. At the bottom left, it talks about preparing new patent applications, so meeting with inventors and seeing what their invention might be. Personally, I tend to draft these applications less now. Those are drafted by people like Ben, but they do require input and insight into that. So I'm involved in that process as well, and talking to the inventors and also talking to our assistants. And then if you look on the right-hand side of the clock, looking at FTO and opinion work, so reviewing documents and writing reports and seeing whether the landscape is clear for our client, whether there are any blocking patents, and looking at the documents available and then providing a written opinion or a telephone opinion for a client. I do a lot of working with colleagues, so a lot of the written work we do is on our own in our office, but that doesn't mean there's not a lot of collaboration. As I said, we work a lot with trainees and other assistants in our team, but also working with other partners on projects they're involved with, seeking their advice on things, providing a sounding board or a sanity check for them. So we're not all just working in isolation. We've talked a bit about business development, and that could also involve contacting prospective clients and planning trips. So we don't just go and see one client. We were going to go and do a trip to the US. We try and make it a week-long event and see how many people we could see in that period. And then the very bottom right-hand slide says opposition and appeal work, and that is one of the things I talked about a minute ago, where a third party can respond to a patent once it's been granted. They can oppose it, and we're involved in quite a lot of those. So that's something I do on a daily basis. I'm going to stop sharing these slides and pass over to Ben, who I think is going to share his slides. Ben, do you want to share yours, and then we can maybe take questions all together at the end?
Sounds good, yeah. Share these now. Cool. Hopefully you can see those. I'll probably just go through them in similar fashion, just popping through it slide by slide. So yeah, hi everybody. My name's Ben. I'm a trainee patent attorney at D. Young. So I'll just run through a few of these slides as to why you might be interested in pursuing a career as a patent attorney and what life is like as a trainee. So firstly, just a little bit about myself. I did my undergraduate degree in natural sciences with a focus in developmental biology at the University of Cambridge. I then stayed on to do a PhD in molecular and cell biology. And then I eventually joined D. Young in November 2021. I was sort of finishing up my PhD and starting the job at the same time, which is quite common. And yeah, there are people here for a variety of backgrounds, lots of people with PhDs, lots of people with masters, years in industry. So there's a real sort of diversity of backgrounds. So I'm reasonably far along in my life as a trainee, I guess. So I sat my first sort of UK foundation exams back in sort of 2022, January 2023. And then I did my first European foundation exam in March 2024. And I've recently just sat the final qualifications for the UK and Europe. So I'm quite far along in my sort of training now. It might be the last time I ever have to do exams, who knows? So as you can tell from that, and as with quite a few other professions, there is a specific route to qualification that involves sitting quite a few exams. So this slide just provides a sort of quick overview of like a typical route to qualification, which involves joining a firm as a trainee, then sitting foundation exams in the UK and Europe. So a quite common foundation exam in the UK is the Queen Mary course. And then sitting your final UK and European qualifying exams to reach the point of qualification. So these routes to qualification can vary depending on where you work. And it's also worth noting that the format of the European exams is changing, which might provide a bit more flexibility in when you actually sit the exams, but they're still in quite the early stages of actually changing that format. So I think in the next couple of years, I'd imagine a more sort of stereotypical route will be established, but I can't see that it changes too much in terms of timings overall. So as I said, I started in 2021, and I'm almost at the point of qualification, depending on the exam results. That gives you a sort of average, sort of typical amount of time that it might take to qualify since starting. And yeah, just to again flag the changes to the European qualifying exams. They're becoming a bit more modular, I think, and they have like a specific amount of time that you have to have been in the career before you can sit them. But with the updates to the European exams, this might mean that you can actually sit them a bit more sequentially, doing some years, some another year, which might help take a bit of the pressure off the exams generally. But that's just a quick overview of the exams. And if anyone has any questions about exams in particular, feel free to drop any questions in the Q&A. But to move away from that, I'll just take it back a little bit and just discuss why you might actually consider a career in patent law in the first place. So looking back to when I was first considering the job, I was definitely enticed by a few of the things that I've listed here. And as I've gained sort of more experience in the profession, I've realized there are a few things listed that I didn't realize at the start, but I've actually found really enjoyable as part of the job as well. I think one aspect about the career that's sort of quite a common draw for a lot of people, is that you want to feel like you can use your background in science and use your PhD and that sort of scientific background is something that's very important to you, and you want to sort of continue that into your career. And so after I'd finished my PhD, I was sort of feeling that academia was maybe not necessarily the place for me. But yeah, I wanted to really keep up that sort of scientific background. And so I first came into sort of contact with patent law at a careers fair at university. And that's when I sort of first was shown what the job really entails. And I think one thing to stress really is that this is a job for people with a background in science. It's a job for people that have an interest in science and scientists in generally. Obviously, the term patent law would lead you to think that it's just primarily a law-based career, but that is, whilst obviously there is a lot of law involved, and a significant amount that you need to learn on the job. But fundamentally, you do have to have a strong background in your technical field, whether that's molecular biology, chemistry, physics, and that technical background you apply in your job on a day-to-day basis. So this really is like a job about understanding and explaining science and then doing that in the context of a legal framework. So you really do get to apply that technical background, and that's something that was really important for me personally. Obviously, there's lots of other reasons why you might be interested in a career in patent law. As I mentioned, there's lots of learning on the job, specifically the legal side of the job, which when you first start is completely new to you. So you're constantly learning about new legal aspects of the job and developing other sort of skills. So it's very rewarding in that sense. And if you have any interest in law, then you'll also find that aspect of the job very enjoyable. Other things that I hadn't really considered as much when I started was how much sort of commercialization you'd sort of be encountering. And obviously just the general stability in the profession is another sort of key draw, I think. Another thing that you might want to consider when thinking about a career in patent law is just some of the key skills that are sort of expected of a trainee and a patent attorney in general. The job requires a lot of writing, a lot of presentation of arguments. So written and verbal communication is really, really up there. So as Jenny mentioned, one of the things that we do a lot as patent attorneys and as a trainee is something we refer to as prosecution, which is where you're essentially in communication with the different patent officers and sort of trying to convince them and argue with them that actually your client's invention, which is new and really exciting, is new and exciting. And quite often they'll come back to you and disagree with you. So you have to present arguments to them using a combination of your sort of technical background and then putting that into some sort of legal framework to show them that actually your patent should be granted. So to do that, you've really got to be able to put together a good sort of written argument and provide convincing data, combining all of the sort of aspects of your background. You've also got to use a lot of analytical skills, properly analyze various situations. So the patent office in their communication with you might present a number of different documents, such as prior applications, research articles and reviews, and they use those documents to sort of argue that what you're showing in your invention isn't necessarily new, or maybe might not necessarily be considered very inventive. And so you need to collate all that information together and put it into an argument as to why that might not be the case. And again, it's really helpful to be able to formulate quite succinct and accurate persuasive arguments during that process. Another skill that's really important, I don't think it can be stressed enough really, is the attention to detail that you need for this job. Everything that we do, all of our work is under a lot of scrutiny, whether that's from the patent office or whether it's from a potential competitor for a client. And so it's really important that we prepare really thorough, really accurate documents in pretty much everything we do. And on top of that, it's a deadline-driven job. And so making sure that we're on top of that side of the work is also really, really important. Obviously, we work as part of a larger team. So we have a lot of work, assigned to us as a team that we can distribute. And so having that team-based skills is really important, but you're also expected to work quite autonomously at times. So the ability to work independently is really important. So having the ability to have a mix and cope with both situations is very useful. And then, as I mentioned, sort of working to deadlines is quite important. And I'd say that this varies quite a lot as a trainee. Often the deadlines are quite far away, and so as long as you stay on top of your work, it's not a problem. But there is always the chance that a client will come to you last minute, for instance, and say they need something done urgently, and you've got to be able to prioritize and reprioritize to try and get that work done on time. So it's a lot of managing your docket, managing your time, to make sure that you're meeting those deadlines. So that's just a few essential skills, really. So what does the typical day for a trainee look like? So comparing this to Jenny's slide, for instance, I've touched on it a little bit already, but it does vary depending on what stage you are in your training. And as Jenny mentioned, there isn't really a typical day because your work varies so much. So when you first start, you do really get involved with real cases pretty much from day one. And so you'll be in a lot of supervisor meetings, preparing work for those and getting feedback on those. One thing that you begin with quite early on is prosecution, which I just mentioned, is that back and forth between yourself and the patent officers. And you'd often be drafting those letters directly to the patent office, the European Patent Office, the UK Patent Office, or amending your patent application in some way so that you can respond to that objection that might have been raised by a patent office. And once you've prepared these letters, that's when they'll get reviewed by your supervisor or case attorney, and then you get plenty of feedback on that work, which then becomes this iterative process of actually learning and understanding the law behind what you're actually doing. So we've got the background in science, but then it's how do we apply that into this legal framework of patent law, which is obviously the thing that's completely new to you as a trainee. And so the feedback is really useful at actually figuring out what makes a strong legal argument, what legal arguments you can make in the first place, things like that. So that's a big aspect of your sort of day-to-day practice when you first start, is really moving up this learning curve, I guess, and figuring out how to prepare legal arguments. But obviously that's just sort of one aspect of what you might do in a day. If we look to the clock again, you might be preparing new patent applications. So once you've got a bit more experience and understand how a patent might be drafted well, because you've gone through all these stages of prosecution, you can then get brought into helping prepare patent application from scratch. So meeting with inventors, drafting those patent descriptions, drafting the claims for a patent, which covers what your invention should be. And again, that all then gets reviewed by supervisors, case attorneys, and you get feedback on that work. And again, you sort of figure out what the best approach is, and you have the support to do that through every stage of like preparing the patent application, preparing a response during prosecution. A lot of time you might spend studying technical and legal tests. Obviously, when you first start, the legal side is completely new, but there are lots of resources out there that you're pointed to quite early on that are very helpful in understanding patent practice, patent law. And then again, just working with your colleagues generally, as Jenny mentioned, when you first start as a trainee, there are lots of other trainees working alongside you. You'll maybe start as a cohort of a few trainees, and then there'll be trainees a few years above you, some few years below. And so it forms like a nice network and support group so that you can, you might have a question, you think, oh, that's a bit of a stupid question. Maybe I'll just ask a trainee. I'll do that first. And you can figure out what everyone else thinks. And you also have like a really diverse group of people from different backgrounds in science. So you might come across something that you weren't necessarily that experienced with based on your technical background. So for instance, some peptide therapeutic, but that someone else did a PhD in that. You're like, oh, so-and-so, can you help me figure out what this technology is all about? So there's a nice network there for you to really rely on. And so that's a big part of the day as well, is just communicating with your support base and with everyone. But yeah, asking questions is a big part of the job when you first start. You're not expected to know anything. And so you're asking questions pretty much on a daily basis to other trainees, to the partners, to associates, to paralegals. So there is a real sense of community in that. And then, yeah, just a lot of reading case documents, applications, reports. And I think, again, yeah, the day-to-day practice varies so much based on You might be working on drafting response one day, preparing a patent application the next day, doing some digging around the prior art because you're helping out with an opposition the next day. It's just very, very varied. It's also varied in terms of the technologies that you encounter. So I have come across many different technologies since starting, and I've just tried to include a few images of the different ones that spring to mind. So I've worked with sort of small peptide therapeutics, antibody-based therapies, and new antibody sort of biotechnologies, oligonucleotide-based therapeutics, a lot of antisense oligonucleotides, GMOs, cell therapies, so CAR T cell therapy, which is a big one in cancer treatments at the moment. Also sort of large-scale industrial uses of various biological factors, large-scale use of industrial enzymes, industrial bacterial populations, things that I hadn't really considered were patentable when I started. So yeah, you get a real sort of variety of technologies, which again makes the day-to-day job really interesting because one week, yeah, you'll be working sort of on a cell therapy. The next week, you'll be working on a new enzyme that's used in a certain process. It's just very, very different day to day. But then it also varies depending on the sort of type of work you get. Jenny has mentioned a few of these as well. And we get to sort of get experience in all of those as a trainee. You do a lot of prosecution and drafting, as I mentioned. One thing that you might not always get experience in, depending on which firm you join, is opposition and appeal work. But at DYoung, we are very involved in oppositions and appeals, and trainees are expected to help out with that as well, which provides a really interesting perspective on the job. So, as Jenny mentioned, you might be working on behalf of a client to oppose a competitor patent that's recently been granted, and you want to try and present lots of arguments as to why your competitor patent might not be new, might not be inventive, it might not have the appropriate data in there to actually support the effect that it claims. And so we do a lot of work in sort of researching that, helping out with preparing those oppositions. And then that provides a very interesting perspective when you're doing the drafting work or the prosecution work, because you're sort of seeing it from the other side. You're seeing, oh, that's a really good attack I can use as to why this invention isn't new. I should probably think about that when I'm drafting my own patent application. So I think it's a really good opportunity for trainees. And then also freedom to operate in landscaping. Again, your client might need to know what's out there already. They might want to launch new technology, but they need to have an idea of what the landscape is or what other patents are out there that might cover something that they want to do. So again, yeah, you get a variety of different projects that you're working on at any one time, which then again lends to the sort of variety of work that you get to do. Finally, I just want to chat a bit about career prospects. I think there's a really sort of strong progression in the job as well. So like once you finish as a trainee, once that's done, it doesn't end there, because then you can start working on, obviously, you're a qualified patent attorney, work your way up to being an associate, work your way up to being a senior associate, maybe even a partner. So it doesn't just stop at the trainee level, which is nice. You can keep going there. And then finally, just very briefly, if you are interested in a career in patent law, it's really obviously very useful to apply directly to firms. You can also consider recruiting agencies, but personally, I just applied directly to the firms themselves. And you can find vacancies on most firms' websites. You can look on IP Careers, which is a good source of vacancies. And again, firms are always looking for technical assistance in a variety of different backgrounds, variety of different technical fields. So yeah, I would have a look on websites, and if you have any queries, you can email us recruitment. And yeah, that sums it up. That's life as a trainee in a nutshell. But again, if you have any questions, feel free to pop them into the Q&A, and we'll do our best to answer. I'll stop sharing if I can.
Okay, great. Thank you very much. Really appreciate that. So we haven't had any questions yet. So I'm going to ask Bernice. Bernice, if you're able to, perhaps you could ask some questions on behalf of the department.
Yes. So, in terms of starting, I mean, I'll start with the question, your side of the presentation, Ben, and ask some questions just relating to somebody who's, so they've just finished a degree, for example. If somebody hasn't gone into doing a PhD, would the route to working as a trainee patent attorney, would it be similar to your route?
So if you don't have to have a PhD first of all, to be a trainee to get a job in patent law. It's useful to have a PhD, but you can have a variety of different backgrounds. There are lots of people that start with master's degrees or a year in industry. I would say that once you're a trainee, the route to qualification is the same, but getting into the job will obviously vary depending on your background. I think it's useful to have something like a master's degree or something like a year in industry or a PhD, something that gives you a bit more experience in the more technical side of the job. As an undergraduate, you get experience in a bit of lab work and in theory, but I think having that extra level of like either a more commercial aspect by having a year in industry or the more sort of lab-based side of it is very, very helpful for getting into the job for a start, and also just giving you that extra level of experience to sort of properly understand sort of more of the technical sides of the job. So yeah, I don't know if Jenny, if you have any comments on that as well. But I would say
I would say some firms insist on PhD. We don't. We're unlikely to take someone who just got a 3-year undergraduate degree. People just don't have quite enough experience about them at that point. So we like people to have done something else. I wouldn't suggest doing a PhD just to get into the patent profession. I think it would be an incredibly difficult thing to sign up to do, just to become a patent attorney. But provided you've got a really high level degree, it won't matter. I would say it's a very competitive job to get into, a very competitive career to get into. So what you're looking to do is to distinguish yourself from other people, and a lot of people do that with a PhD. But once you've entered the profession, the training is exactly the same, whether you've got a PhD, a master's, or even just a undergraduate.
So I think that brings me to my next question. So having started as a junior patent attorney, how long does it take before somebody becomes a partner? How much training do they have to go through?
So it takes at least 4 or 5 years to become a qualified patent attorney. After that, you can become a partner at any point, I guess. It's up to the firm, but generally you're looking at minimum 10 years, more likely 15.
So, and is this the top? Is this the highest position as a patent attorney? Can you go beyond a partner status, or how do you grow as a partner?
So lots of firms have different levels of partners. So you start off as a junior partner and then you become a more senior partner. Otherwise, the level is fairly static. You are then a partner of the firm, but you grow and develop every day. You experience different cases, you take part in different things, you move into working with different clients. So you're growing and developing all the time, even if your job title is the same. Another route is the route through which people work for a pharma company, for example. You could be head of IP for a small or large pharma company. And that's sort of a different route where you would be more commercially involved.
And being a partner, reaching a senior level in a patent firm, are you able then to do more independent work? And I'm thinking about consultancy.
So if you are a partner in a patent firm, you are unlikely to then do any consultancy. Your clients are clients of the firm. You can be a consultant patent attorney, where you are then self-employed and you can then work for whoever you want to work for. But if you are a partner of a firm, your clients would come through the firm. You can go and find those clients however you want, but you wouldn't then consult for them individually. You would work with them through the firm.
And in terms of, because a lot of students ask me this question, in terms of salary, what would you expect as you progress from a trainee position to a senior position?
That's a good question. So our trainees start on about 40,000. Don't quote me on that. It varies from firm to firm, and it varies from year to year as well. But at the moment, our starting salary is about 40,000. That increases each year. It increases further when you qualify. So our qualified patent attorneys are on around 100,000. And then that increases further when you become a partner. That's very firm specific, the partner salary, because you don't have an actual salary. You're a partner of the firm and you have a remuneration which is based on the profits of the firm. So that's not something I can give you as a figure, but obviously it increases relative to a qualified attorney.
That's a lot, I have to say, when you become, okay, so, but I mean, if we go back to thinking about the exams, so the more like developmental stage, and how what would you expect in terms of the material that you would be examined on?
So it varies depending on the exam. So I've just sat the European final exams, and a lot of them are sort of quite practice-based. So the exams themselves will be presenting you with a situation. For instance, you've had a communication with patent office arguing that your invention isn't new, isn't inventive, and you've got to be able to respond to that. So it's testing your day-to-day job, basically. And it presents you with a technology that sort of, in a way, sort of simplified so that everyone can understand it. Because, you know, you've got people from various different backgrounds, so like physics and biologists sitting the same exam. And so they'll present you with a bit of a situation, a technology, and you've got to be able to sort of understand the technology and then prepare a response. And that's an example of one exam. You have other exams that test you on your abilities to draft a patent application, an exam to test you on your abilities to draft an opposition to a competitor patent. And then you also have an exam that is primarily focused on your legal understanding. So we presented with lots of smaller legal scenarios where you have to be able to apply the law and say what would happen in each sort of situation. And so that's the final European qualifying exams as well. Obviously, the European exams are changing, but they will test you on the same types of subject matter. It will be practice-based subject matter and also legal sort of scenarios. In the UK, it's fairly similar. So the first qualifying exam that you do, your foundation exam, at Queen Mary anyway, tests you on intellectual property law in general. So you get a nice overview of the whole field and not just patent law. You're tested on patents, trademarks, copyright, and design law, which gives you a sort of good foothold into IP in general. And I believe with Queen Mary, you also then have a way of sort of going into more trademark law if you wanted to. I'm not sure how common that is, but you are, in a sense, sort of qualified in that area a little bit as well. And then the UK final exams, again, are a bit more legal and practice-based. It differs in the final UK exams from the European ones because the UK's will test you on your knowledge of infringement of a patent as well, which isn't something you really get tested on to a great level in Europe for various reasons. But then you're also tested again on legal scenarios, advising clients in different situations. So it covers a lot of different topics. You have to know a lot of the law, and you have to sort of have like a good knowledge and understanding of your general day-to-day practice as well. I said that's the exams in a nutshell, to be honest. But yeah, the European ones are changing slightly, but it will be testing you on the same content. So.
And that was, yeah, I think that does help too. Yeah. That's quite comprehensive. So yeah. No. Okay.
So just to let you know, you may have missed it, but there is a question that came through in the chat. Just to remind you, if you could put the questions in the Q&A, it makes it a lot easier for us to answer them because we don't see them coming up in the chat, I'm afraid. But there is one that's
we can answer the one out of the chat. So the question is, out of the patents you hold, how much licensing activity do you see regionally, US versus UK? So a patent application is regional. A patent is regional. So a patent would cover, Europe is a slight anomaly, but usually it's just a country. So you would have a US patent and a European patent and a UK patent, would be within the European. So you don't get licensing across those jurisdictions. You have to choose which countries you want to have patent protection in. Obviously, it's more expensive to have more countries. We see our very smallest clients maybe having just a UK or just a European patent. Our very largest clients, our big pharmaceutical clients, have many countries. Most are somewhere in the middle. So Europe, US, Japan, China, Australia, New Zealand, India, Korea, maybe Israel. So all the major commercial jurisdictions. You've also asked, is it better to be a patent attorney in the US versus the UK? I would say the UK, but possibly I'm biased. The major difference is that to be a patent attorney in the US, you have to take the US bar. So they are lawyers, and then they specialize in patents, whereas we are not lawyers. We haven't been to law school. We're not qualified solicitors. We are qualified in science. And we then move into the law and train sort of on the job and do the exams that Ben's talked about. So you can find that the scientific knowledge of US attorneys is not as strong because they have a law background rather than a scientific background. That's certainly not the case for everyone, but it can be the case for some people.
I think I've come to the end of my questions. I can't think of anything that you haven't covered already quite well.
That's fine. If anybody has any more questions, I'm sure you can follow up with Bernice or Kim afterwards and they can pass those on. But otherwise, it's been lovely to talk to all of you, and thank you for having us.
Great. Thank you. So I think Kim.
Yeah, absolutely. No, I just want to say final thank you very much, Jennifer. Thank you, Ben. Really appreciate you taking the time. Thank you, Bernice. And also a huge thank you to everyone who came along and asked the questions. We really appreciate you coming and joining us. And of course, a recording will be made available afterwards. So everyone who registered will get to watch this. So thank you again. And I hope you have a fantastic week. All the best from us.
Thank you.
Thank you.
Thank
Bye.
you.
Yeah, bye.
Thank you. Bye.